In the previous chapters, we extensively spoke about the technical functions of Parliament, what really happens in Parliament, how Parliament works to serve the country. Now, Parliament is representative of the general public as they are elected through a general election. It is important that we know how the public can interact with Parliament and also what privileges or additional privileges are afforded to parliamentarians by virtue of their office. Let's first take a look at what parliamentary privileges mean. These are special powers and immunities given to members of Parliament to allow them to function freely, effectively and independently. The privileges and customs of the Sri Lanka Parliament are taken from the practice of the House of Commons in the United Kingdom. Parliamentary privileges are included in the Parliamentary Powers and Privileges Act No. 21 of 1953. The legal provisions under this Act can be broadly categorized into freedom of speech, Parliament's right to regulate its own affairs, which is known as exclusive cognizance, and limited freedom from arrest. Let's start off with the first privilege, the freedom of speech. Within Parliament, members are entitled to freedom of speech. This means that a member of Parliament cannot attract civil or criminal liability for anything they say in Parliament. Members include the President and the Speaker and any member presiding in Parliament or sitting in any committees. It even extends to individuals who give evidence to Parliament or a committee. This freedom of speech extends beyond speech and covers any documents. This may include petitions, bills, resolutions, motions and other committee reports presented in Parliament as well. Number 2. Parliament's right to regulate its own affairs, known as exclusive cognizance. This applies only to proceedings of Parliament. Now, under this privilege, the Parliament is conferred with the following rights. The right not to have the legality of its proceedings questioned outside of Parliament, the right to remove strangers from Parliament, the right to discipline members for their conduct, and the right to order the attendance of witnesses and produce any paper, book, record or document. Number 3. The privilege afforded to parliamentarians with regard to freedom from arrest. In limited situation, members of Parliament are free from arrest. A member cannot be arrested when proceeding to, in attendance at, or returning from any meeting or sitting of the House for actions related to civil proceedings. This privilege also comes with 3 exceptions. It does not apply if the grounds for arrest are a contravention of the 1953 Act, an act of insolvency under the Insolvency Ordinance, or an emergency regulation made under the Public Securities Ordinance. A member may also be detained under the Public Securities Ordinance. If a member is imprisoned or arrested, the House should, by custom, be informed immediately through the Speaker. In addition to the above, a Member of Parliament also has the right to attend. This means that no person should obstruct a member on his way to Parliament to attend to his business. Here, even a member in custody can claim to be provided with the facility to enable him to attend the business of Parliament. What would happen if a Member of Parliament breaches privilege? According to the Act, in case of a breach of privilege, the Parliament may punish a person by giving a firm warning or an admonition or removal from Parliament or its area, and if the offender is a Member of Parliament, then Parliament, in addition to or in lieu of these punishments, may suspend that member's service to Parliament for any period not exceeding 1 month. If the offender is not a Member of Parliament, then Parliament may order that offender to be prohibited from entering Parliament or its premises for a period not exceeding 6 months. The offences that Parliament can deal with are listed in Part B of the 1953 Act's schedule, and the Parliament shares jurisdiction with the Supreme Court over the offences contained in Part B of the schedule, while it is only the Supreme Court that can deal with the offences contained in Part A of the schedule.